Thank you, Yolanda, and good morning, everyone. It's a pleasure to be with you all today. When Vicki and Patty asked us to come and do this presentation, I thought they told us just to get up here and be disruptive, but unfortunately, I don't think that's what our call was. Patty kept reminding me along the way that I wasn't to be disruptive on stage. I was to actually give a presentation. So it's our pleasure to be here today to talk to you a little bit about a topic which I've been telling everyone our goal is to try to push everybody just to the edge without pushing them over, but to also try to bring what we think is a realistic view of the future of courts across the country and around the world. I'll start off by showing you a few pictures, and maybe some of you in the room who are on the younger end may not know what they are, and maybe some on the other end of the spectrum may also not know what they are, but I think it'll prove the point here. So let's talk a little bit about what disruptive innovation really is. Some of you recognize what that is. My kids don't know what that is or what that is. This thing is what I thought when I was growing up was something that you were just supposed to blow in to make it work. All of those, of course, pieces of technology which are no longer around and certainly have been disrupted by types of innovation. So to just get us all on the same page this morning, I wanted to give us a definition, a framework for what disruptive innovation is. And so here's our definition we're going to be using today as we talk about disruptive innovation as it applies to the world at large as well as to the courts. And it is basically a process by which a product or service takes root initially in simple applications. Generally, this is something that's a very simple solution to some problem. Generally starts at the very bottom of a market. They don't generally come out and it'd be an innovation that's at the top of the market and then quickly and relentlessly moves up through the market, ultimately displacing the established competitors. So we'll give some examples as we go throughout this morning, but that's the definition we're going to be looking at. Something that is actually literally going to disrupt people in the marketplace through some simple technology or solution that begins at the bottom of the market and moves its way up. This definition was originally put out there by Clayton Christensen and Joseph Bauer in 1995. And here are just some other examples of types of disruptors that are just generally known. Obviously, personal computers were the disruptor to the mainframe days. Some of you may have worked in courts when we had mainframes and mini computers. Obviously, other types of things like mini mills instead of the big mills, cellular phones. I don't know how many in the room still have a landline in your house. So it's not very many of you, but my guess is if we keep looking at that over time, we'll see that change. Obviously, community colleges and now even perhaps online colleges are beginning to replace the traditional college route. And you can see even retail medical clinics displacing traditional doctor's offices. Actually, if you look at even some of the more recent disruptors, I don't know how many of you have had a virtual doctor visit, but through our insurance at our office, there's virtual doctor visits, and that is the most convenient way for me to go to the doctor now because I can go to the doctor while I'm sitting in my office or on my couch, and has been very innovative as well. So the caveat to all of this when we talk about disruptive technology is that not everyone agrees that the disruption is actually likely to happen. So there are people who disagree that we're going to continue to see disruption. And in fact, one of the examples is from a recent article in The Atlantic that says that today's technological innovations actually pale in comparison to the types of disruption that happened in the past. And so obviously there are people who disagree as to the impact that technology will have as far as disruptive. It might be smaller disruptions. And there are some companies who in the past have thought this, and I'll show you a few of them. Nokia, I don't know how many of you have one of these phones, but if you do, then maybe we should talk. But obviously they thought that they had the solution that would be the end all to this game, and they no longer are in the market. Blockbuster thought they had the deal. You could even sign up to go in, not have to wait in line and get their market, but as we know, not many Blockbusters left. And probably the most famous example of a company who thought they would never be disrupted and they would have the edge on the market forever is this one, Kodak, who thought when they had their solution, they didn't need to innovate because obviously they were going to be the solution from photography forever. And as we know, probably not many of us have a Kodak camera anymore. In fact, very few of us may actually even have a camera anymore because of our cell phone technology. So disruptors are occurring, and the fact of the matter is, whether or not you agree fully, we do expect it will have some impact on the world around us as we continue to go forward. So let's talk a little bit about how disruption occurs, because if we know it's going to happen, how is it happening, and what are the causes for disruption occurring? So traditionally, digital disruptors really unseat traditional business by one of three ways. And these are really, to me, when we look at this from the court perspective, I'd like you, as we go through these, to think about what types of things might this apply to in your court or in your state or in your country, and see how this goes. So the first way is cost. So digital disruption can happen by cost, and we'll spend a little time on each one of these in just a second. The second way is through improving customer experience. And the third one is what we'll call platform. So those are one of three ways, and we'll go through each one of them, but one of those three ways, if there is the ability to improve or appeal to customers in one of those areas, then we're likely to see disruption. So let's talk about cost first. This one's pretty straightforward, but obviously the goal here is, are there things that a disruptor can do to improve the cost, to either make it less costly? So that may be through some sort of operational improvement. A virtualization, so we may see that something that has traditionally been done in a more traditional format, some sort of delivery of service or technology, ultimately gets put into a virtualization where this can happen without the cost. So interestingly enough, I remember when I was on the NACM board and we started talking about live streaming. This is one of those things where there was a discussion about what is that going to do to the traditional conference, and I think what the NACM board would tell you is it's actually grown the conference, because as people begin to see the technology and they get to access what's happening at the conference, they want to come, and they also, if they can't come, can still participate in the learning. So we see some of this virtualization occurring as well. And then lastly, innovative business models. So we've got some of these examples of the way that people have used cost to really disrupt. So you have freemium pricing, so some company or institution offering their services for free to get you hooked. And then, of course, you want to upgrade to a better service because you're now hooked. Or you can do so many for free, and then ultimately you have to sign up for their service. Group purchasing, reverse auctions. These are all the types of things where through the improvement of cost, you can see disruption occur. So once again, one of three ways that disruption can occur. The first one is through cost improvements. Here are some examples of that. Skype is one of the ways, Spotify, Groupon, LendingTree. These are types of companies that have now come into the market and are being disruptive to their marketplace because of the ability to lower cost for the user. The second one is through customer experience. And this is one I think that when you start thinking about how this impacts the courts, I think this is perhaps a place where we may have the potential of the biggest amount of disruption in the court system around the world. I always tell people, and I won't ask for a show of hands, and I know I'm being recorded and live streamed, and I'll probably hear about this back at home, but I always tell people, I've worked in the court system for almost 20 years, and I feel like I on my Twitter, I describe myself as a designated court nerd. I feel like I live and breathe and talk about courts all the time, and feel like I know a lot about the court system, especially in Texas, and from my experience on the NACM board, about other states too. And I always say that if I had a dispute, I would figure out any way I could not to go to court. And I am the state court administrator in Texas, and many of you in this room may feel the same way. And why is that? Because of the customer experience. There are a lot of issues with that. And so if we feel that way, how about our customers? How would they feel? And so some of the ways that disruption can occur in this area is through simplification. Can a entity or company come in and make it simpler to do what the customer wants to do in a way that then improves their experience overall? Efficiency. Can it be done more efficiently than what they're able to do through the traditional market? Convenience, of course. Can I now do what I want to do from the comfort of my home? Can I do it in a way that's more convenient for me than perhaps going to the traditional marketplace for that service? Of course, personalization. Can I do it my way? That is now, I guess, a tagline for some companies. Have it your way. We all want everything done the way that we want it done. We don't want to do it the way everybody else does. And so when a company or a market can come in and be able to personalize it to your unique needs, there's a high likelihood of disruption. Here are some examples. I was talking with some folks this morning at a table about, when we were younger, we wanted to watch a video, and the problem was if someone didn't have a VCR, how could we watch that Care Bears movie or whatever else it was we wanted to watch? Of course, now my kids, they can watch anything they want, anytime they want, anywhere they want, and it can be personalized for them. I can watch now the favorite TV shows I want to watch when I want to watch them, not whenever they're on television. So, it's things like this where there's able to be personalized. Amazon Prime, I don't know how many of you took time away from the conference this week to enjoy Amazon Prime Day. Some of you, I saw you on your apps in the middle of the conference session shopping, but obviously trying to make sure the customer has the experience they want personalized for them. And it's a little bit disturbing when I actually am on Amazon and then go somewhere else and come back and they know exactly what I want and they have it right there for me. It just shows the ability to personalize it to my needs and what I'm interested in. So if we can improve the customer service, or if someone can improve the customer service, we're likely to see that type of disruption occur. The last one, and this was a really interesting one, especially when you start thinking about this from the perspective of the court, is the third area where disruption can occur is if someone can really take advantage of the platform issue. And when we talk about platform, we're talking about the way that services are delivered to the marketplace. So this is where generally you are able to connect through a digital space, providers and consumers to allow them to find each other. Basically, is there a way that you can connect services, connect the provider with the consumer without them having to really go search and find each other? So if a service can do this, they're more likely to displace or the traditional providers that are out there where you actually have to go find them to do that. This generally relies on some form of innovative technology to be able to make that connection in some way or another, and it oftentimes leverages big data and human nature. So I go back to the point earlier about knowing exactly what I want and connecting me with those services. They are using big data. They know what people in my demographic want. They know what I want because of my past history of searching and other types of information, and so they're connecting me with the service I want. I don't know how many of you are like me, but sometimes when I go to search for something, I type in the first word like what, and it actually has the rest of the question that I was going to ask. And I often wonder if my phone is actually listening to me, and perhaps it is, I don't know, but in some way the technology is getting smart enough to be able to predict what we need. And you think about this from the perspective of courts. If a provider can begin to predict what our customers at the court want, they can perhaps get a leg up on the way that we do things in the court system. Here are some examples of using that platform to connect. So obviously, these are just a few examples of Facebook, Craigslist, Snapchat, Wikipedia. You get a platform. Wikipedia is an interesting one because, as all of you know, if you've read the reports, it's actually been found by many to be more accurate than Encyclopedia Britannica and others because of the fact that it's constantly being updated by millions of people around the world. We had a court case in Texas recently where the Supreme Court actually chided a litigant or a court for using Wikipedia to define a word in an opinion. I thought that was an interesting opinion. I won't tell you what the word they defined was. It's a sort of a common slang word. But Wikipedia is a good example of using that platform to connect. So when we look at disruptive technology, and as we think about this morning, be thinking about, basically the disruptors are going to occur in one of these areas: cost, customer experience, or through platform, or some combination. If you can get something, or if you see something in the world where they're able to actually work across those spectrum, it has a high likelihood of being disruptive to that marketplace, the existing technology. So the thing that we do know is that we are not accustomed to technology in the court world. We've had we've had our brand, we've been in charge of this market for centuries at this point. And so for the most part, we've not had a competition. If someone wanted to resolve a dispute, we were their solution. So guess what? We're open 8 to 5, Monday through Friday, maybe. So you can come to us whenever you're ready to get your dispute resolved. But what we know is that is somewhat changing today. So when we look at this, a lot of people believe that there are industries that are less vulnerable to digital disruption. But what that oftentimes does is creates complacency in the organizational leaders, because we say, well, we're less likely to be disrupted, so we are just going to sit back and do what we're doing, and people will come to us to continue to get the services that they've always got. And what I would say is that is very dangerous, and my goal today is to really push all of us in this room to challenge that type of thinking as we look at the way we deliver services. So let's talk about why we might want to actually leverage the disruptive innovation concept. The goal here is, how can we actually try to not be complacent? How can we actually, in the court system, look at this through a new lens to actually improve the way we deliver services? And obviously the biggest one, and this is one I keep challenging folks I'm talking to really think about, is who are we serving? We are serving the public and their experience with the courts. I had a recent conversation, I think it was actually while I was here, and one of the conversations was, well, if we make that change, then we won't be able to generate as much revenue to the courts. We'll have to lay off staff. We'll have to have fewer judges. And my question, this person and I we agreed on this issue, but the conversation turned back to, but who are we serving? Is that what we're serving? We're serving the court employees and the judges and all that, or are we serving the public? And the question is, we should be thinking about who we serve and using that to leverage this concept to improve our services to the public. Obviously, another big reason to leverage disruptive innovation is to try to reduce cost. All of us in this room, I'm assuming, at some point or another, and perhaps today, are constrained by our budgets and what we have available to spend money on. And the question is, could we use disruption or disruptive innovation to actually reduce the cost for the services that we're providing while still maintaining that high level of experience for the public? I think many times our automatic reaction when we're looking at tight budgets is, what services can we cut back and reduce the customer's experience, positive experience with the courts, instead of looking at, could we use disruptive innovation to actually increase the services at the same time reducing cost? So we'll look at that some more as we go throughout today as well. The other thing, too, is to make justice available to a wider audience. I don't know about you, but I've been looking and listening to things that have been happening, like the Conference of Chief Justices Civil Justice Initiative and other types of initiatives are out there. And what we continually keep hearing is that people are not able to access the justice system. And one of the big reasons why is because it's too difficult, too costly, not convenient from a time experience. And so could we think about things differently and use disruptive innovation to actually make our services and our justice system more available to a wider audience? And I would think that all of us in this room think that that's a very positive thing to do as we go forward. And then lastly, of course, to preserve fairness, neutrality, and transparency. So one of the challenges that we face is, if we're not able to deliver the services the way that maybe we would like to deliver them and the way the public wants them to increase that access, then people may go elsewhere to get their disputes resolved. And then, of course, is that fairness, neutrality, and transparency there in the process. So if we're able to embrace what we're going to be talking about today with this disruptive innovation, what we are talking about, then we can actually see improvements in those areas. So what I would encourage us all to do is really take a look at disruptive innovation through the lens of the court. So we're going to spend the rest of the time today, and Margaret's going to spend some time with some very specific examples talking about how we can leverage this disruptive technology in the court. So let's talk about a few examples of things that we see as disruptors. When I say we, I'm referring to the Joint Technology Committee. It's been referred to a couple of times today. That is a joint committee of the Conference of State Court Administrators, NACM, and the National Center for State Courts. And we held a focus group last year with industry leaders, not just court folks, people who were from the private market, from judges, court administrators, IT professionals within the courts and outside the courts, and said, what types of things do we think are currently teed up, are currently disrupting the courts? And so there's a whole paper on this that's on the Joint Technology Committee website. I believe it's in your materials. But I want to specifically talk about some of the examples that we identified there. Probably one of the biggest ones that we see as being disruptive is data. And I know all of us in this room really like our court data, and we oftentimes complain about the lack of court data or the accuracy of it. But what really all the folks around the room in that focus group said is that one of the most powerful things that courts have is our data. But yet the problem is that we don't use it effectively. And so if someone else is able to get that type of data from us through whatever means that is, they are going to be able to disrupt us in ways that perhaps we're not prepared for. But we can also use that ourselves. One of the second biggest disruptors from a technology perspective is, of course, intelligent automation. It's no longer a dream world anymore to think about computers actually replacing humans doing jobs. I don't know how many of you have set up for Wall Street Journal alerts on your phone, but literally this morning during the business meeting, I got an alert from Wall Street Journal about an article saying that robots have replaced people in retail stores in China and talking about this issue. So what we're beginning to see is this intelligent automation of services. The question is, how much of that's occurring in your court, and could we use that, or will someone else use it to be disruptive to us? We've had a lot of talk at this conference about online dispute resolution, but one of the biggest disruptors that we're seeing and have been seeing is the advent of online dispute resolution beginning to occur, whether that's through the private marketplace providing this service outside the courts or us in the courts embracing it. But more and more people are looking for a different way of handling their disputes than the traditional court system, and ODR is one of those areas where we believe it will be disruptive. Digital evidence. How many of you are dealing with digital evidence issues in your court, from body-worn cameras, videos, all those being entered? Several hands going up around the room, but I would venture to say that within the next year or less, all of us in this room are going to be seeing more and more of this issue. And how are you going to be able to deal with that issue? It's going to be somewhat disruptive to the way we're doing things. I don't know if you know, but the largest provider of body-worn cameras in the country in the United States has now offered to law enforcement free body-worn cameras for every officer in the country if they sign up for their storage service. There's that freemium pricing thing at work again. But digital evidence is going to become a bigger and bigger issue, and the question is whether or not we're prepared for that. Cyber attacks. Do I need to say more? We've heard a lot about that this week and previous months, but from a court's perspective, obviously there's more and more interest in trying to look at this issue. Some of you may have heard the story recently about a defendant who got really frustrated with the court for the decisions they made, and so they went home, hacked into the court system, changed all their records, and said, yeah, we'll see who won this battle. So cyber attacks are not a joke, and they are perhaps going to look at disrupting us. They're also non-technical disruptors, so not all of this is technology, but I would venture to say that every single one of us in this room have seen decreased case filings. I know at the state court administrator level, we've been talking about this the last few years, not just minor decreases in case filing. We're talking about significant decreases in case filings in each of the states and counties. And for those of you that are looking at workload studies and things like that, we know that can be disruptive. A cost-benefit imbalance where we're still spending money on functions that maybe we started years ago doing, and we're still spending that money on that when in fact we're not getting the same benefit that we did those years ago. So that imbalance is really becoming somewhat of a disruptive issue. This one's an interesting one, and quite frankly, probably one of the most controversial pieces of the JTC product, which is that we believe that one of the major disruptors is going to be the decoupling of the bar from the court. And when we talk about that, what we're talking about is the fact that the bar's interest in many places no longer match the court's interest. So who are we serving? What is our goals? And so you'll begin to see these issues where you'll see a separation between the bar and the court on various issues. And I think the belief is that that will just continue to be exacerbated as courts continue to try to serve the public. Mandatory arbitration clauses. This has been something that's been being talked about for some time, but where basically folks are being diverted from the courts because of agreements they've signed in different contracts along the way. A positive one, but somewhat disruptive, is restorative justice, looking at this item of trying to make sure that we're working with, for instance, in the criminal side, with victims and defendants to try to be able to have that restorative justice, which may change the way that we deal with things in the court system. And then lastly, civil justice reform. As I mentioned a second ago, there's a big push right now to try to really reform the way that we do civil justice so we can increase access to justice. And this may make our courts look very different than they do today. So those are some of the non-technical disruptors. So all that sounds easy, right? Unfortunately, what we believe and what we know is that the obstacles to making this type of change for courts are quite daunting. Here's just a few of them. Obviously, things like jurisdiction and venue. Some of you may be like me in my state, where we may have judges and staff in places in the state where they're not quite as needed as they were before. And so you think, well, we'll just give them different cases, let them help out other places. But then our rules and our statutes are set up in such a way that that's not possible. So jurisdiction and venue. One of the ones on here I think is really important is the whole issue of protectionism. I mentioned that earlier, where we're more concerned about protecting our institution as far as our specific workplace, where the people that we work with every day, our staff, our judges, the way that we've done things, that we sometimes get more interested in that issue than we are in the goal that we should have of serving the public. That is not statutes and rules, unfortunately. I don't think any of us have any statutes that are an obstacle, but maybe we do, I don't know. Maybe we need to move them out of the courtroom. But basically, those are obviously issues. And then obviously you see some of these other ones as well. Procurement is one of the ones that we've identified as a particular, because our procurement laws are based upon trying to protect, to make things very transparent and make sure there's no unethical activity. But oftentimes those do provide obstacles to really quickly responding to a need that we have that perhaps the private sector doesn't have in the way as well. So what we know is that some disruptors are going to succeed. I'm just going to tell us all that. Our courts will look different because we will see disruptors occur. And so what we think is going to happen is that some aspects of the court's day-to-day business will disappear. I will tell you this is very controversial. And some of the talk is, should we even really be worried about some of the parts of the court's business disappearing? And I'm talking about even case types. Are there certain types of things that we should be okay with saying, you know what, if someone else can provide that service better than we can, perhaps we should just let them do that and us focus on the parts that we feel like we really need the court system. I would challenge us all to really think very hard about that because sometimes I think when we're trying to focus on too much, perhaps we're losing focus on what's really most important. So some of this we know will occur, and should we be actually somewhat facilitating that disruption? So one of the things that's really interesting about this whole idea of disruption is that there's a lot of changes that are necessary to do that. But the things that are probably the most important in trying to encourage disruption are culture, tradition, and mindset. Those traditionally are more important to knowing, getting changed in your court system than the technology. Quite frankly, as my CIO in Texas tells me all the time, we can get the technology to do just about anything you want. Typical technologist answered, right? But the problem that we have oftentimes is the culture, the tradition, and the mindset. Getting people to change the way we think about things is more difficult than implementing the technology many times. So we've got to think about that and begin to try to work on making sure our culture and tradition and mindset are in the right place. So a couple of things that we can do to really prepare ourselves for this area of digital innovation, disruptive innovation. one of the things that we really need to be working on is being hyper aware. And that is really a job that we all should be doing, and you being here is obviously shows that this is what you're trying to do, but really being aware of what's going on around us at all times, hyper aware of the types of changes in internal and external environments. What's the medical field doing in this area? What's technology doing in this area? Being really very cognizant and aware of what's going on, because we need to be able to sense those changes before they really occur and as they're occurring. The second one is to really have informed decision making. Are you using data in a way that can be able to allow you to make decisions that are in response to those types of changes that you're seeing around you? Do you even know what's happening with your caseload, for instance? Or do you know how this technology might impact this way that you're doing things? And one of the things that's important is to be able to have the data to be able to make that decision that's informed. And then lastly, the ability to act quickly and effectively on decisions. This fast execution is really important. One of the things we've been saying in the Joint Technology Committee is we have to get away from the idea that IT projects can last 3 to 5 years. That's no longer acceptable anymore, because if it's scheduled to last 3 or 5 years, we know it's going to last 4 to 6 or 5 to 7. And by the way, by the time you implement that project, the technology will have already changed and you're already behind. So we've begun to look at how can we quickly and iteratively begin to innovate in this area. So fast execution on decisions is important as we go forward. So there's a model that was put out by the Global Center on Digital Business Transformation. It really sort of puts this into perspective, and it sort of shows that you're using the scan of the external business environment and your internal environment, using data from that to really be hyper aware, drive that informed decision making, and have that fast execution. And I would challenge us that this is really the model that we should be following as court leaders today. So a couple of things that's important to know is that we know where these generally exist, and they're traditionally available in small startup companies. They're able to be hyper-aware, have informed decision-making, and fast execution. What we also know is it's nearly antithetical to the operational processes of most courts. This is generally not how we've operated. We've not been fast execution, had informed decision-making, and been hyper-aware. And so this is going to require a change in the way that we deal with issues going forward. So one of the ones that we got to work on is to have a change in our court culture. And one of the ways to do this is to really come up with a can-do mindset. We should all be challenging us and our staff and all the court leaders around us to try to figure out how can we do this, how can we be able to make this innovation occur. Create this environment that facilitates innovation. We need to be continuously trying to innovate every day. We should never be in that complacency standpoint. We should be thinking about how can we change things to make things better. I've been telling people lately when I've been talking about this issue that this word right here on the screen is the court's F word. We do not allow for failure, and I think it's generally government at large, but because of that, people are afraid to try new things, and I think we have to change that. We have to be able to say it is okay to fail if you fail quickly and you fail small. We don't want to spend $1 billion and then fail, but we do want to be able to encourage an environment where it is okay to fail, because otherwise people are not going to be willing to try things and we will be behind. If you look at the companies that are out there that are disrupting, they have failed over and over again, but yet they keep pushing through to try to be able to do that, and ultimately when they are able to succeed, they are very disruptive to the issue. Listening to the least and the newest among us. A lot of times we get in our rooms and we have our meetings, and it's the people who've been there the longest, who have the most experience, that don't have a fresh perspective. How many of us have user groups where we're actually talking to the people that are coming in and using our services and asking them their opinion? How about the brand new employee who just came in from some other market and says, why in the world are we doing it this way? Those are the types of people that we need to be making sure are part of the conversations that we're having. Challenging assumptions. I would say it's important, even if you agree with something, that we should be asking why. Why do we want to do it that way? Why is that the best solution? Is there a better solution? So challenging the assumptions. And then embracing model revised statutes and rules. We really need to be looking at what types of things do we need to change to make sure that we can have this. And the one thing I would say that's really important in this area is when we start thinking about technology and the way to do it, many times we take our existing rules and practices and we build technology that fits within that. And the question I think we ought to be thinking about is, let's design the best solution and think about the best solution, and then what types of things do we need to change in rules or statutes that will then allow that to occur instead of the other way around. That's certainly a big change from where we've been. So a couple of things in technology: digitize, enhance our data gathering and analysis tools so we can have that information. Design for increasingly tech-savvy users. That's somewhat of a no-brainer at this point. We're seeing more and more tech-savvy people. Embracing tech standards so that we can have somewhat of what I will use a 90s word, plug-and-play approach to be able to have different types of technology work. And probably one of the biggest challenges for the courts is consider outsourcing. We oftentimes try to do everything internally. Folks, we don't have the research and development budget that companies have out there. We need to be thinking about using the outsourcing technologies that we can in the private sector. And with that, basically, public-private partnerships become really important because we can begin to see other types of providers help us, partner with us to provide better services to the public. And lastly, I would say on this one that we should be thinking about crowdsourcing, using the public to be able to help us with this issue. So another thing, obviously, when we're looking at this is what we've called in our JTC paper as sustainable innovation. There are some things that may disrupt the courts, and maybe we should just embrace it and be okay with it. But there are some things, as I mentioned a second ago, that are going to be so critical for us maintaining that we should be trying to do sustainable innovation. Disrupting ourselves to some degree to be able to sustain those operational things that we would like. So with that, I'm going to turn it over to Margaret. She's going to talk about some of the things that are going on around the country. And then if we have time at the end, we may have time for some questions. We'll see if we can get there. Margaret, thanks.
So I'm going to pick up on one of the particular themes, which is kind of the possible disruption around customer experience or user experience, and how vulnerable courts are to that, as well as some strategies that courts can be thinking about, that courts can be employing to really improve the customer experience. So what I do at Stanford is teach classes and do projects all about the future of courts. What kind of innovations are coming? What should be on the agenda. And how we do this is by talking to the customers. So we just hang out in courts, in the waiting areas, in the self-help centers, all around the Bay Area. And we talk to people who are waiting in line, and we ask them, how is your case going? What have you experienced? How long has it taken? What do you want to see changed? We try to get as many of these user voices into the conversation about what innovation should look like, what the agenda should be. So we do lots of focus groups, lots of on-site ethnography, lots of documentation, and then design workshops to get them creating and defining what the better court would look like from their perspective. Including, this is a group of people who have just recently gotten out of jail, so they've been through the criminal justice system at least. So we bring them in, this is in Escambia County in Pensacola in Florida. We bring them in with a bunch of legal aid lawyers, and we say, what went wrong with your case? Not just, that there was some injustice or that they didn't get the outcome that they wanted. Obviously, they're just coming out of jail. But what could have been better from a procedural standpoint, from the court standpoint, from your public defender? Like what, in terms of the services, if you are a customer as a criminal defendant, what could be better, at least, that we can make the justice system seem more procedurally fair, if nothing else? So we have them come up with ideas. We have them go through what their experience of the justice system was and then define how it could have been better. We try to get that user point of view defined and then made into an action plan. So here are some of the ideas that have been coming out. We've grouped them together into some patterns. Hopefully some of them can be inspiring for your court. So first of all, one of the biggest and least technological demands is just more visuals. So obviously we know that the court produces a lot of written text-based resources, especially for self-represented litigants, whether it's on websites, on handouts, on worksheets. You have to start putting pictures on things. Just the simplest thing is making things visual and thinking things in terms of procedures, in terms of processes. This is what litigants need in order to really understand and appreciate what the court has to offer them. It's really a low-cost kind of investment, whether it's putting more visual posters up, converting your worksheets and handouts to more visuals, making your websites more like this and less like text dumps. But this is a huge demand from users and something that really easily could be a quick win for self-disruption. A second thing, a bigger investment on your part, but maybe something that, again, working with private vendors could be a real demand from your case management system vendor, is better analytics. So obviously there are private companies, in this case Lex Machina, that was just acquired by Lexis, that takes all the case data about how a case proceeds, how judges and other decisions are made, and then makes it operational for a lawyer or for a litigant. So giving that kind of inside baseball, moneyball view of what a court case looks like. That allows for some amount of prediction, but really just better understanding of how the court works, how long things take, and what to expect with a given jurisdiction or a given judge. This is enormously powerful, also very, very expensive. Lawyers pay a lot of money for this type of analytics. I think courts should be not waiting for private companies to take your data and then operationalize it like this. This is an enormously, there's a huge business model potential in providing better data and then analytics interfaces on top of that data. Why aren't courts doing this? Obviously, there are private companies that are thinking beyond intellectual property, which is what Lex Machina started with, intellectual property case data. There's a huge amount of interest in being able to better see and understand court data. So why aren't the courts doing this? That's a question you should be asking yourselves and asking your vendors. Why, if you're allowed to see the data about all of the cases that have gone through your system like this, and then if you can possibly have a business model that you sell this access to lawyers or to litigants. Hopefully give it to litigants for free. But another technological type of self-disruption is the ability to go through a case, especially from a self-represented litigant point of view, in an online procedural kind of way. So right now, at least in California, the Self-Help Center website lays out all the steps you need to go through to, for example, get a probate guardianship or to deal with a traffic ticket case or any of these kind of common self-represented litigant tasks. Why is there not a really clear guide that lets people go through step by step, fill out all the forms, hopefully entering the data once, populating all the forms immediately? There have been some start and stop initiatives to at least fill out forms better online, e-file better. But what we're seeing from the user's point of view is they want a comprehensive single entry kind of guided experience, not just in filling out a single form, but in doing all of the tasks related to a given process, like filing for a probate guardianship. They want the court to provide this service that takes them from a vague interest in maybe I need a guardianship through all of the steps, through all of the filings, through notice and service, through the resolution of it. They want a single portal on the court's website that gives them all of the data about their case and lets all of their filings and to-do tasks there. And I know some counties, like Orange County in California, have been experimenting with a single customer portal. This is enormously appreciated by users. So thinking about the type of guided experience you could be providing on your website. Another demand or wish list item from the litigants is better coaching from the courts. And this is not about legal advice. This is literally about where to go, what bus line to possibly take, what to wear or not to wear, how to speak to a judge. But all of these kind of small factors, kind of like the mundane parts of being successful in a court case, people feel clueless and intimidated when it comes to the justice system. That's one of the main kind of emotional takeaways when we're talking to people in line or after they've gone through the legal system. They feel enormously out of place when it comes to representing themselves, or even if they have a lawyer, they feel, even if they're a PhD level smart, even if they're a lawyer level smart, they have great degrees, they're intelligent people, being inside that court building, inside that courtroom, renders them feeling helpless and small. So how do we as the court, hopefully, provide some coaching that gets them to the point where they know they can at least take care of all the smaller procedural things? Another one, obviously, online court dispute resolution is really popular, and we see some experiments going on in Ohio and Michigan with a project that came out of the University of Michigan Law School, Matterhorn, that allows, at least for traffic tickets, online dispute resolution of the ticket through mobile phone interface. this is the future. This is what people want. They do not want to have to come and wait in line in security, wait in a waiting room for 2 hours to get arraigned before the traffic commissioner. They want something that they can do on their phone and not just pay the bill in full, but do a little bit of negotiation and get discounts. Because obviously most courts around the country have some kind of online payment system for traffic tickets, but then you're paying the retail price. People want the negotiation. They want to have a little bit more of a back and forth and not just have a straight payment. So how can you do that? How can you reduce the amount of traffic lines in your, at least for the arraignments, and do all of that on mobile phone? And finally, one of the other things is, especially as there are more competitors coming in for courts, courts should be thinking of themselves like a business, which means thinking about search engine optimization, how people find you, know how to use you, and actually choose you over competitors. So that means when you try this, when you go back home to your computer, if you search who comes up as the #1 kind of court provider on a Google search, are you the #1 hit? Are other people, are other private services or other services coming up as the top hit on Google search? So this is what we're working with when it comes to big data and smarter artificial intelligence and search engines. I personally believe that a public institution like the court should be the #1 hit when it comes to people searching for legal help in their jurisdiction. So our team at Stanford is working with Microsoft Bing and with Google on this to try to make sure that public dispute resolution channels, meaning the courts, are the #1 hit and they get some priority on a Google search. But this is something that you as a court, you can improve your search engine optimization by talking to your webmasters about what metadata is put onto your website. And you can talk to me about the project with Microsoft and Google. We're trying to make sure that every court has their data structured on their website so that when people do search in your jurisdiction for legal help, they'll get information about the courts that's presented in a much cleaner and structured way, and you're not competing with advertisements and other types of websites. So I'm just going to conclude with a few thoughts about how you actually get to these kind of user-centered disruptions. What are the more procedural types of questions a court should be considering to self-disrupt? And to do that, I'm going to borrow from some other federal governments and international sources about how they are trying to self-disrupt, the kind of practices that they're embracing. And first is talking about procurement and how we can do procurement that's more responsive, more modular, and doesn't get you stuck with a bad vendor or a bad project. So the Federal Digital Service Group 18F has wonderful resources online about modular procurement that allows for shorter deadlines, more oversight, more ability to control a procurement contract. So I'd recommend looking into this concept of modular procurement. Second of all is agile development, which basically means building stuff quickly, testing it quickly, and iterating. So kind of fail early, fail fast, and then respond to it. So don't wait 3 to 5 years to decide, okay, this project is not going the way we wanted, let's shelve it and pretend like it never happened. How do we have quicker check-ins and then more ability to change course as needed? The UK government has taken agile development as a whole across all of its government services, especially as it's tried to put more services online. They have an enormous amount of resources and modeling that the US can be borrowing from when it comes to having government development of digital services, particularly in this quick, rapid way. Third, looking to British Columbia, our neighbors to the north, and Canada, this human-centered design focus, which is really talking to the users, bringing them in, bringing their voice in. There's been a lot of work in British Columbia about taking this user-centered access to justice approach, especially for self-represented litigants. So there's a lot of case studies, especially around building more user-centered dispute resolution online tools. And I'd recommend this article, particularly from Shannon Salter and Darren Thompson. They're both court administrators and legal aid self-represented litigants, advocates in British Columbia. That's a great case study that we can learn from here in the States. Fourth is looking in Chicago. Chicago is really very forward-thinking when it comes to digital services that are user-centered and agile and driven by agile development. And there's a group there that's built a civic user testing group. So exactly this question, how do we actually get the voices of our litigants? How do we be hyper-aware of the trends and the needs of the people around us? Set up a user panel, a testing group, where you can ask people who have already gone through your courts to take half hour out of their time and focus group the new technology plans that you're thinking about building. Before you invest lots of money in a new technology or operations project, Put it through focus groups. Ask people even on their mobile phones to vote up, vote down. So, for example, in Chicago, they do lots of testings of any new type of city-based government service. They have focus groups set up in public libraries around the city, and they pay people $20 Visa gift cards for half hour of their time, and they get lots of rich feedback from people of all different walks of life. And this is what we as courts should be doing, is opening our doors and trying to get more of the litigants' voice in. And finally, the last type of procedural thing to be doing to get to self-disruption is really being smarter about our data. And I think this has been a theme across the conference, but especially a commitment to open data. And this is a conversation perhaps to have with your case management system vendor. How do you make sure that you own the data, and hopefully that you're making some kind of portal online that allows for the public to be able to access the data about your court? Whether it's the case details, the other types of performance indicators, these types of data sources will allow for a whole ecosystem of new application developers, those private groups, those startups, to be able to build apps that can integrate with your case management system or otherwise. This is how you can start building an ecosystem of other people, hopefully building applications and innovations that work with you and not against you. So having better, cleaner, and more open data is just a hugely important factor for anything when it comes to self-disruption. So with that, I'll say thank you. I think we have a little time for questions, so happy to take any questions.
One thing that Margaret said, if you have questions, there's a couple of mics going around, so if you could raise your hand, we're happy to take some questions, or if you have a comment, that'd be great too. But one of the things that Margaret said made me think about something that Shannon said, which I think we ought to challenge ourselves. Shannon Salter from BC, she's been working on their ODR system in BC, and it's been highly successful. And her comment at a recent conference that I was at was, if you're in a room with your court managers and your court leaders, and someone says, I think I know what the public wants, you should immediately stop and just say, no, we're going to go. Because we oftentimes think when we're sitting around the room that this is what the public wants, and many times we are absolutely wrong. So rethinking that, I would just challenge us all to really have that thought. Anyway, with a question or a comment, we've got a few minutes. We'd be happy to, we save those here, we'd be happy to take them. No one wants to be brave and... Anyone? Okay. Well, thank you all so much. I think we're going to make a transition to the next plenary. We appreciate your time and hope you took some things from this morning. Thank you so much.